So my name's Yesenia. I'm the director here at Project Sentinel for our dispute resolution programs. Um, we have a variety of jurisdictions, and we'll go over that in just a second. Towards the end of the presentation, we'll have time for question and answers if you have specific questions. A little bit about our agency. We're a nonprofit. We have three departments. I cover dispute resolution, so we counsel and educate people on their rights and responsibilities. We also conciliate and we mediate. We have a mortgage department, which is referred to as our housing counseling. They focus on foreclosure prevention, anything mortgage related, including delinquency, helping people refinance, reverse mortgage. Then we have our fair housing department. They primarily focus in discrimination, folks with disabilities, people with service animals, or who need modifications in their unit. Most importantly, alleged discrimination. Our mission is to promote fairness and equality of housing opportunities for all persons and to advocate for peaceful resolutions of dispute for community welfare and harmony. A little bit more about the department I work in, dispute resolutions. We refer to it as Tenant Landlord. As I mentioned earlier, we have a helpline within Santa Clara County. We cover different cities, including the unincorporated part of the county, where we help pretty much anyone who calls, including housing providers, on what their rights are and responsibilities. We help people conciliate and mediate to try to help them reach an agreement. For cases that we open, we also work with both parties. We interact, we do Zoom mediations, we do virtual meetings, we provide information and referrals. This presentation's only for educational purposes only, and we do not provide legal advice. So I want to explain a little bit about the difference between mediation and conciliation. So conciliation at Project Sentinel is basically when someone calls our helpline and they're not aware of their rights, we educate them. And if they want, we can contact the opposing party, whether they're a tenant or a landlord, vice versa. And based on the information and education that we're providing, it kind of steers the people based on the subject matter into resolution. Sometimes people who have a better understanding of their rights are more receptive to accepting the help and trying to reach some sort of resolution because what they thought initially was not accurate. Mediation's a little bit different. And so when we're not successful in conciliating cases, sometimes it happens where we're not here to force anybody, first and foremost, to reach an agreement. We're here to support the mediation in general, the communication, the respect between the parties, and making sure that they're very clear of what their rights are. Sometimes, most of the time it's successful, but other times it's not. We refer it to mediation. And basically what that looks like is our agency has what we call our general panel of mediators, volunteer mediators. Some are also participate at the day of court. So some of these mediators might be familiar. They have participated and are active in the eviction calendar at the Santa Clara County Court, helping people with the day of court evictions as well as the civil harassment calendar. And so they come into a mediation with the parties knowing nothing about the case, never had details about the case. They don't know the part or anything like that. So conciliation for our case managers is more hands-on. And so that's the difference between the two. These are right here. These are basically, we use a book called the California Nolo Press Book. Since we're not allowed to provide legal advice, that's like our go-to book. And so I really like sharing this chart with the public because it has by city and county which has rent control or which has just cause evictions or which city or town has required mediation, for example. And there's a key at the bottom if there's multiple. And on the right side is the same chart, but in a bigger format. And it's by county too here. So, for example, you'll see other counties that are not listed here that we do not cover. So we don't cover San Leandro or San Francisco, for example, but we are in Santa Clara County. So there's state protections and there's local protections. Usually the local ones are going to be called ordinances, is what they call them. So right now I'm going to focus on the state protections. So I'm sure a lot of you, if you haven't already heard, Assembly Bill 1482 is known as the Tenant Protection Act. This was enacted right after COVID and actually during COVID in 2019. And it only applies to specific properties. Now, the most important thing for housing providers is that they are required to notify every one of their tenants if this state protection applies to their tenant or if it does not apply, meaning they're exempt. If a landlord fails to notify the tenant, then the tenant's covered until they do. And so the way to notify tenants is there's a paragraph that needs to be provided in the lease agreement now. Went into effect back in 2020. It's called the noticing requirements. So every tenant should be notified if it's in their lease. You'll see it sometimes typed up as rent cap. You might see statewide protections. You might see the language AB 1482 or rent control. Those are all indicators of being notified of this state law. And if you're not sure, you're welcome to call our hotline and ask. Um, as I mentioned, it only applies to specific properties. First and foremost, the property must be older than 15 years of being built. There needs to be more than 3 units on the property. So if it's a single family house that has two ADUs and it's not owner occupied, it would be covered. If it's a duplex and the landlord does not live there, it's covered. And any complex with 3 or more units is automatically covered. Um, so noticing requirements, the year it was built, and then it also provides rent caps. So there's rent caps depending on the area that you're in. So that can vary. For Santa Clara County, the maximum allowed under this state law is 7.7%. And then the other part to it is going to be the just cause. So just cause is basically a reason that a landlord is asking a tenant to move out. It's either the tenant's fault or not their fault. And we're going to get into more detail about that too. And then it also provides relocation depending on the type of notice a tenant gets. So let's go right into our flyer here. So this is our flyer. And the first thing that we already discussed is a noticing requirement. So landlords must give notice. TPA is the Tenant Protection Act. Same thing as AB 1482. In this box here, you'll see housing that's not covered. So, yeah, this means exempt, for example. So going back to the rent cap here that we were just covering, Santa Clara County is capped at 7.7%. And the rent cap is determined on the Consumer Price Index. So 5%'s the base, and then plus the CPI. And it varies by county and sometimes city, depending on where you're located. Now, to be more technical, the city of San Jose, for example, their rent cap maximum allowed is 5%. So there's an exception here. It can be confusing. 7.7 is for Santa Clara County. But if it's a tenant who lives in San Jose, they're not allowed to get a rent increase that's more than 5%. So a lot of the questions that we get, and a common one is usually, how do I know which applies to me because they both apply? So the one that always provides the most protection is the one that supersedes. So although it's 7.7% in Santa Clara County, if you're a resident in San Jose, you're more protective under the San Jose city protections. Those are called ordinances. Whatever's most protective is what is enforceable. So if a tenant, for example, gets a rent increase for 7.7% in San Jose, guess what? It's not valid because it's not in compliance with the city regulations. Sometimes the cities provide a little bit more protection, but it can vary. In Santa Clara County in general, it's less than 10%. So the landlord does need to give a 30-day notice when increasing the rent. And sometimes landlords will give two increases a year, but regardless, the total amount increase should not be more than the 7.7. As I mentioned, this changes every year. August 1st, the new rent cap goes into effect. So it's usually posted on the state website. If you look up Consumer Price Index, you'll see it posted around probably June or July, sometimes May, but it can vary. The third component to the Tenant Protection Act are terminations. Termination is not an eviction. Termination is what causes an eviction. In fact, there's numerous things that cause an eviction, but a termination is a landlord's first step on asking somebody to move out. And it's broken down into two categories. It's either the tenant's fault or not the tenant's fault. That's what we call just cause. A just cause, really, in other words, is a reason. So housing providers must give a 60 or 90-day notice. Usually it's 90 days for Section 8 participants or people who have a subsidy. Otherwise, it's 60 days. It needs to be in writing. It must have a reason. Reasons for at fault, meaning the tenant violated the lease and it's their fault they're being asked to move. Well, examples of those can be maybe they've been warned about smoking, or they've been warned about noise, or maybe they damaged the property, or maybe there's illegal activity, things like that. Maybe they moved in people that weren't on the lease and did not ask them to move out, stuff like that. No fault means that the tenant did not do anything wrong to be asked to move. Examples of those are the landlord wanting to move in their family, the landlord wanting to maybe remodel it. Maybe it was tagged by code enforcement that it's not habitable, there should not be people living there, things like that. So those are the two categories. Now, there's been some changes to this state law, and it's with regard to asking someone to leave for either owner move-in or substantial remodels. So before the changes went into effect, we would see tenants getting notices to move out that the landlord plans on moving in, for example, but then 2 weeks later, they see their apartment up for rent for a higher rent, for example. Or maybe a tenant got a notice that the landlord was going to remodel, but then they see it up for rent on a website. So there was a lot of notices being given in what we call bad faith. This is page 3 of our flyer here. So um, the changes are, if an owner asks a tenant to move out because they intend to move in themselves or family, in addition to the 60-day notice, they're supposed to give the tenant in writing, again, addressing the reason and relocation. They also are required to do a few more things. The first one is they need to notify the tenant who it is that's moving in, the name, and how are they related to the owner. And the second thing is the tenant may ask for proof that the person moving in is actually related to the owner. The third thing is this must be done. So the owner moving in themselves or family needs to be done within 90 days, and they must live there for 12 consecutive months. If they move in 90 days and end up moving out in 6 months, regardless of what the circumstances are, if the tenant can prove that the landlord gave them a bad faith notice and they see it up for rent, not only does a tenant have the right to return there, but they must be compensated for all moving expenses. So it's really important that housing providers give these notices in good faith. And you know what? Sometimes it doesn't work for everyone. And if that's the case, mediation's an option. There's protections, there's a law, but there's also reality. And sometimes, a tenant and a landlord may want to agree to something else that works for them. That's totally fine. Best thing is put it in writing. And so that's what our group of mediators are help trained to do, is to help people resolve things. Not our way, but what works for them. The other part to this is number two here. If it's the intent to demolish or remodel a unit. So if a landlord asks a tenant to move because they want to remodel, say, for example, a duplex, right? Well, in addition to the 60 or 90-day notice, they're required to write a declaration to the tenant why they're asking them to move, what are the work dates, when does the work going to start, when it's expected to end, contacts to the contractors they have a right to get. But the landlord's also required to give the tenant a copy of the actual permit that was approved by the city to do the work. And the most important thing about this is that the landlord needs to notify the tenant that they have the right to return. They have a right to move back in, not only at the same terms that were there in place before, but also at the same rent. So these are two new changes that are really providing extra protection for the tenant when it comes to receiving notices of no fault terminations, is what we call them. These two reasons here are not the tenant's fault. It's just the landlord's reason. And if it's not the tenant's fault, the landlord's also required to provide relocation. So, for example, in San Jose, they have relocation amounts that are in the thousands based on how big the unit is. When I say unit, I mean the place that you're renting or the place that you live in. It could be an apartment, it could be a house. It can get very expensive. But in other parts of Santa Clara County, it would be the state protection, which is this, and it's only 1 month of rent. So in those notices, when a landlord's asking a tenant to move out, they're actually required to put, I am going to waive your last month's rent, or they must give the tenant a check for the last month's rent. That's the relocation that's required under the state laws, 1 month of the rent that they pay. Even Section 8 holders are entitled to the relocation. And for people who have vouchers, all housing authorities require a reason when the landlord's asking somebody to move out. So that's something good to know. This is another flyer that we have. Um, it's mainly other local and state updates we like to track and just put people on notice. Positive rental payment reporting. This basically means that if there's more than 16 units in the property, the landlord has to offer the tenants that they have the right to have their rent payment reported to the credit bureaus. And if there's a cost, it must not be over $10. The other one is no fees for check payments. So for the notice, for example, we just talked about the termination notice. Landlords are not allowed to be charging fees um, for the way a tenant pays their rent, for example, or for serving them a notice, no matter what kind of notice it is. Victim of domestic violence, the third bullet here on the left, Senate Bill 1051. Landlords are required to change the lock at their own expense within 24 hours of receiving documentation that the tenant or household member has been a victim of domestic violence. If the landlord fails to change the locks, the landlord must reimburse the tenant within 21 days. And then basically the third bullet here is that the landlord may not retaliate against the tenant or try to evict them for being a victim of domestic violence. Moving along here to the fourth bullet point at the bottom left, discrimination. There's no such things that, especially rental ads, there should be no ads that say we don't accept Section 8. That's discrimination. Landlords must, when people have vouchers, for example, whatever their portion of the rent is, a lot of the ads I'm sure that you've seen will say you need to make 3 times the rent, and you see a rental that's 3,000. your income must be 9,000. Well, if it's somebody that's a voucher holder, it's three times of what their portion of the rent is. So if their portion is 1,000, the minimum that they need to earn per month would be 3,000 to be eligible. So these are things that landlords and any housing provider, property management companies, they're not allowed to have that. Basically, they need to make this exception based on the tenant's rent portion. And then there's also other considerations of someone's ability to pay. Maybe if, they're disabled and are on a fixed income but have other sources of income, that needs to be taken into consideration. Um, the other one here, moving along to page 2, the Consumer Price Index. This is where we get our information based on the rent increases. So it's published even numbers of the months. So February, April, and then the whichever amount is published in April is what goes into effect for the rent cap in August. The one that's published in April. That's really good to know. Um, Assembly Bill 2801, this is related to security deposits. So more than anything, what has not changed with security deposits is that when someone gives the key back, um, the landlord has 21 days to refund or send the tenant an itemized statement. If not a full refund, a partial refund, and a list of what the tenant's being charged for. Starting April 1st of last year, after a tenant moves out, the landlord must take photos before and after any repairs or cleaning to be deducted from the security deposit, and to provide the photos to the tenant along with the itemized statement I just went over. Beginning in July of last year, landlords must take photos of the unit at the start of the tenancy. So before it's rented to the tenant, if there's any repairs or cleaning, and then after. So documenting photos is extremely important, especially if people end up going or taking housing providers to small claims court for their deposit back. It's the law now. And so it's a requirement. It's going to be very hard to be able to prove, to a judge if, a unit was not in good condition without photos. Same thing for a tenant. So best practices, no matter what your role is, if you're a tenant or a housing provider, do your own checklist. Make sure you take an inventory list of all, like a checklist of everything you see that's defected in the unit when moving in. Sometimes when people move in, they don't know that the drawer doesn't open all the way or that it gets stuck or it can get off the track or there might be mold developing. Those are all things that you definitely want to take photos and report to the landlord. Tenants cannot be charged or required to pay for professional cleaning unless it's reasonably necessary. And then there's a maximum of security deposit. So if for housing providers, for individual housing providers, if they have less than 2 properties, they can charge 2 months, but anything more than 2 units, it's limited to 1 month of rent now. And then AB 2493 are application screening fees. So for the most part, when someone goes and applies to rent somewhere, the housing provider gets usually multiple applications. And so the housing provider in good faith needs to review and process those applications all in the same way, shape, and form in terms of screening. Um, I mean, there is criteria where someone can be ruled out, right? Maybe they don't meet the income, or maybe there's too many people. Um, the most important thing is that landlords do need to return the screening fees if it's not within a reasonable amount of time, or if they've already selected someone and, they know that other people have applied. What amount of reasonable time? I'm not allowed to answer that. The civil code here does not specify the number of days or months or anything like that. So that's yet to be figured out. But for the most part, um, if this is something that's an issue, mediation is probably the best solution in terms of getting back screening fees because it can get very expensive applying to multiple units, for example. This is a chart from the Department of Justice's website. I like sharing it because the rent increase caps that I was sharing with you guys before in the beginning under the state protections, this is where I got my information. So as you will see, Santa Clara County is not in the San Francisco area bracket for the 6.3, but it does cite all other counties are going to be 7.7%. So this is a really good document to have. Common topics we see at Project Sentinel. Well, we hear about everything, but I would say these are all the common ones. Rent increases, maybe the terms are changing. For example, tenants being responsible for utilities, breaking a lease, abandonment of property, termination notices, right? Someone being asked to move out, deposits, maybe there's mold or bed bugs. Those are maintenance and repairs, habitability, neighbor to neighbor disputes. That's usually common with fences and trees, very common. Um, Small claims, lease violations, quiet enjoyment. That can be noise or smoking, for example, when it's not allowed, especially in multi-unit complexes. Privacy, that usually, a lot of those calls are usually like cameras facing other people's areas. And then local ordinances, people just wanting general information. So a fixed term lease versus month to month. A fixed term lease is a contract. If you break it, you can be responsible for the landlord's loss of rent. Um, but the landlord also in good faith needs to try to re-rent the unit. So there's other things that play a part in that. Examples of month-to-month tenancies, verbal agreements, month-to-month agreements, leases that maybe you started off as 1 year, but maybe they expired, or tenants who've just been paying rent on a monthly basis and maybe nothing in writing exists. Regardless, housing providers, if they ever want to change the terms, whether it's a rent increase or the tenant paying utilities or maybe common areas, things like that, that all needs to be in writing. In fact, anything from the housing provider must always be in a document, always in writing. Text message, email with a PDF, that's not valid service. We covered this in the beginning, what a termination notice is. Um, I did want to share, so there's three different types. 30 days if the tenants live somewhere less than 1 year. 60 days if the tenants live somewhere more than 1 year. And 90 days is always the timing when someone has a voucher. As I again mentioned, this is a landlord's first step into asking somebody to move. In fact, a master tenant, say you're a tenant yourself and you rent a room out, these are also the same requirements that a master tenant would have to abide by, no different than a landlord. So it's really good to get familiar with the timing of the notices. Um, For example, Redwood City, which is not in Santa Clara County, but like the city of San Jose, for example, Sunnyvale, they have their own ordinances. Most of those are related to relocation. Same thing with San Jose. Um, the city is required to get copies of the notices. Um, and then there's also other protections like the apartment rent ordinance for people who live in multi-unit complexes in San Jose. So by city and by county, the protections vary, and that's what our helpline is for, to really help people know what protections apply to them. Change of terms, examples are, as I mentioned, new rent amounts, utility, lease renewals. Maybe someone's going to start getting charged for parking unless they're disabled. If someone's on a lease, though, that has not expired, the landlord is not allowed to change the terms unless the landlord and tenant mutually agree, and they must put that in writing. Habitability. Habitability is basically the condition in which you're living in. Common issues that we see a lot are mold, water leaks, pests, bed bugs. Sometimes it's termites, for example. Always good to notify the housing provider of any maintenance issues or if there's repairs needed. Also keep them in writing, take photos. And then this is a state law. This is also from the NOLO Press Book, the Landlord's Law Book. But it's really helpful. It has a civil code. Knowing the civil code, you can Google it and search up all the details and what it applies to and the in and outs. But basically, a livable unit includes proper plumbing, proper hot water, electrical, lack of rodents or insects, proper garbage disposal, a working toilet, wash basin, shower, for example, proper electrical that's not exposed. So these are examples of what a habitable unit should have. Most recently, at the end of last year, appliances were added to this. If an appliance was there and belongs to the landlord when a tenant moves in, it's their responsibility to maintain it now. Before it was not viewed as a habitability issue, it was more of a repair, where if the tenant requested a repair and it was not done, it wasn't, not that it's not enforceable, it's more of a reduction in service. And a lot of tenants would have to go out and buy a new stove or fridge and then deduct it from the rent. So note here that appliances have been added to habitability standards. Another common topic, abandonment of property. Never assume someone's abandoned the property, but if that happens, always put a notice on the door of a belief of abandonment. You wait 18 days to get notified from the tenant. And or if rent has not been paid in 14 days, you don't want to assume it's been abandoned, but you can, as a housing provider, you can serve a 3-day notice to pay or quit. That's probably much quicker to get a response. Regardless, though, if there's abandoned property, you never want to throw it out. Even if you rent a room to like from tenant to tenant. It's the first thing you have to do is serve a notice of belief of abandonment and a notice for the tenant to reclaim their property. Otherwise, they can hold you liable in small claims court. And so this is what a notice of belief of abandonment. You got to make efforts to contact the tenant. You can serve a 3-day notice to pay or quit if rent is owed. The notice of belief of abandonment, you're not allowed to touch the tenant's belongings for 18 days. And the way to prevent this on the tenant side is if they pay rent, respond to the notice in writing, or if they can show that this happened in one case I had where the tenant was actually on a vacation and they just simply didn't pay their rent. So there was some communication there and it was resolved and the late fees were waived. And that's the beauty of mediation. But again, taking accountability, notifying your landlord ahead of time is also good. And this is an example of what the notice should look like. What should it include? The address. It must include, title it notice of belief, put the civil code, and most importantly for housing providers, sign, date, and write your name and where you can be located or reached, whether it's a PO box or phone number or address, for example. Now, a notice to reclaim property is also given with the notice of belief of abandonment. And so this happens commonly when the tenant's not reachable and their property is left behind. It's actually required for the landlord to take inventory. It's always good to have a witness with you. You can record if you choose, but you basically, as a housing provider, they need to keep an inventory of what was left. A TV, a bed, a dresser, hygiene, um, carpets in the bathroom, take photos because it's the only way to prove what was actually left and to avoid being accused of theft or anything like that. Um, if the value is under 700, it can be tossed out. If it's more than 700, then the landlord's not allowed to throw it out. They must store it. The most important thing is never keep somebody's belongings even if they owe rent. That's not a tool or mechanism to recover the rent. It's actually illegal and they can take a landlord to small claims court. But storage fees can be charged. And this is what the notice of reclaiming abandonment of property looks like. It always must have be signed dated by the landlord. It must have the address. Most importantly, the clause here that they have the right to reclaim the property. That's the whole intended purpose of the notice. No one can be demanded in exchange for returning belongings to pay the rent. Wrongful lockouts can result in damages and penalties. Returning keys isn't required for the landlord to take possession, but actions must be reasonable and documented. And housing providers cannot keep the property if it exceeds 700. This is another common one, landlord's right to enter. So landlords can enter the property, but they must provide a 24-hour written notice when doing so. They need to put in the notice the reason, the date, the time, and purpose of entry and who's entering. If it's mailed to the tenant, it should be 1 week in advance notice. The only time a landlord can enter is if there's an emergency or to assess the repairs. Maybe a tenant complained about a leaking faucet, or maybe there's mold, or maybe there's a rodent infestation, or to make agreed upon repairs, for example. It's okay to show the property when it's being, put up for sale, but the tenants have a right to privacy, and it's not good business to be entering or forcing entry when tenants are still living there. So that's another thing. And also being present during initial and move out inspections. The tenants have a right to be present during inspections. Deposits, security deposits. So we went over earlier how they're limited, right, to 1 month's rent, depending on, the rental property. So no more than two. And also the 21-day refund or at least statement showing what the charges are for, in addition now to the photos. Down here, there's exceptions to deposits for military service members, and this applies to if the landlord's an individual. If it's corporately owned or managed, then they can only request 1 month of a deposit. So that's what this means here. We talked about AB 2801, which is a deposit limitation. We talked about landlords being required to take photos beginning when someone moves in, which is the start of tenancy. We talked about the landlords being required to take photos when the tenant moves out and if they're going to, deduct anything from the deposit. And then this is another new one, AB 414. So if a tenant moves in, and this just went into law on October 6th of last year. So the tenant moves in and Zelled or Venmo the landlord the deposit. The tenant has the right to receive the deposit back in the same format for tenancy started on or after October 6th of last year. So that's another one. 21 days to receive the deposit back. So there's two elements to tenancy, the contract and the keys. As long as the tenant remains in possession of the keys, the landlord can charge rent. So giving back the keys is always good because it shows your last official date you lived there if you're a tenant. So 21 days. Now, if the deposit is mailed, the landlord gets an additional week without being considered late. The courts do the same thing when notices are sent. And deductions can be made for rent, utilities, repairs, or cleaning. Um, and the itemized statement is required if the deposit charges are more than $125. And then the tenant also has a right to ask for receipts, invoices, people who did the work, um, invoices, maybe work orders. It should be provided within the 21-day time frame with the deposit refund or partial payment. But if not, and it's not, then the tenant can ask for it, and the housing provider has 14 days to give that information. It's not a 14-day extension to refund the deposit. It's just for the documentation purposes only. If a landlord does not comply, mediation is an option. The tenant can make a demand or go to small claims court. And then this is the deposit flyer that we usually hand out. It has all the civil codes and it talks about the cleaning, the 21 months, and the 2-month rule for collecting deposits. So this is a good flyer to have. We already covered this flyer earlier, so I'm just going to bypass this one. And then examples of best practices. Keep things in writing. Doesn't matter if you're a tenant or a landlord. Keep things in writing. For tenants, if you're out of state and wanting to rent, for example, that's a common one, or students, for example, do not sign the lease based off pictures. It's really important to actually go look at the unit, meet the landlord, and avoid a scam too. For housing providers to be requesting and offer their tenants to be participate in any inspections. And for both parties, creating your own checklists, documenting the defects in the unit, taking photos of it, notifying the landlord. For housing providers, checking references, and for everyone to get familiar with what your rights and responsibilities are. So these are all key things to note. We have 5 different offices. We are in Alameda County, which we only cover the city of Fremont. In San Mateo County, we have a Redwood City office. We only cover the city of Redwood City. In Stanislaus County, we cover the entire county as well as the city of Modesto. We also cover the city of Merced and Richmond, as well as Stockton, which is San Joaquin County. We're in Santa Clara County and our county wide, including unincorporated areas. We have a Gilroy office, and our main office is in Santa Clara. And then these are all our service areas. We cover a lot of cities where the city contracts us for their specific city. So, like Campbell, for example, mediation is required. In Los Gatos, mediation is required as well as arbitration. San Jose, mediation is offered. We also manage the city of Palo Alto's. They have extra protections for tenants in Palo Alto for like the mandatory response. So basically, if the dispute is within 21 days of calling our helpline, mediation is mandatory for the landlord to participate in. And then these are just some resources here, 211, the lawyer referral service, code enforcement. Bay Area Legal Aid is another good resource to get legal advice, which we don't provide. And the Apartment Rent Association for housing providers. And then our 2 other departments, we covered our discrimination department, which is fair housing, and then our mortgage department, which is home counseling. And that's our program flyer.
Wow, thank you so much. That's a lot of information.
I know I went too fast, but I
No,
did
no,
the
no, no.
best I
This is
could to cover.
amazing. This is amazing. So, thank you so much. Anybody have questions? So, Yesenia, is there any way I can pass your information to the register folks? A couple of people cannot make it.
Yeah, I'm happy to share the slides with you too. I'll send you a
Great.
PDF copy,
Hmm.
and then our hotline number is on there. They're more than welcome to call, and they'll get routed to a case manager that covers that jurisdiction for sure.
Great. Thank you so much. Thank you. Bye bye.
You're welcome. Bye.